Hello everyone and welcome to this new Privacy Espresso episode. Privacy Espressos are quick and short videos where we provide you with the latest updates on the privacy frameworks all over the world, thanks to the members of our alliance in particular, but also with guest speakers. Today I'm with one of our members, that is Franco Larcina from the law firm CCP Law, based in the Philippines. And we are going to discuss with him about the most recent news from the Philippines. Franco is partner of the firm and is also member of their TMT and data privacy group. So without further delay, can you provide us with a quick overview on which is the framework under the privacy perspective in the Philippines?
Sure. Thank you, Alessandro. So the Philippine data privacy regime is primarily governed by the Data Privacy Act of 2012. We also call that Republic Act number 10173. So basically, it's through that law that the state regulates the processing of personal data. And personal data is essentially, it's information that leads to the identification of an individual or a natural person. So that law or that statute is implemented primarily by the National Privacy Commission. That's the government regulator. And the National Privacy Commission, or for short, the NPC, also issues rules and regulations and various circulars, advisories, and opinions to further implement the provisions of the Data Privacy Act.
Wonderful. And thanks a lot for this, quick introduction on your framework in the Philippines. And which are the most recent news you wanted to also share with us and our audience today?
Yeah, so quite recently, actually in December 2022, the NPC issued NPC Circular number 2022-04, which enshrines a new system for the registration of data processing systems, or DPS. It also sets out new rules for the appointment of data protection officers, or DPOs. So this circular, as I mentioned, was issued in December 2022, and it came in effect in January 11, 2023. But notably, this circular repeals the old NPC Circular number 07-01, which sets out the old rules on DPS registration. For one, right, I believe that this new circular demonstrates that Philippine data privacy law is an evolving field. It's a very young area of law. Yes, it's been there since 2012, but the key rules, the key requirements, they're in flux. They're in a constant process of evolution. And just on this note, perhaps it would be useful to highlight that, Philippine data privacy practitioners would really need to keep themselves updated of recent issuances and the rules and regulations issued by the NPC.
Wonderful, Franco. Thanks a lot. And in this regard, I totally agree. But in general, I think all the privacy experts I've been meeting so far agree on the fact that there is need for a constant updating, because we are speaking about a sector that is very and strongly related to technologies. And of course, the progress requires all the lawyers working in the field to be very updated in order to provide best services as you do. In that regard, I heard you mentioning about some key changes that these new circular is bringing. Can you tell us a bit more about them?
Sure. So first, it creates a new system for the registration of data processing systems. So under the old rules, the registration of the DPS occurs in two phases. The first phase is really the registration of the data protection officer, or DPO, and the second phase is when you really register the DPS itself. The new circular does away with that two-phased system. So now it's just one single process, which involves the DPO creating an account, logging into the National Privacy Commission registration system, and then basically the DPO inputs the data. He will provide or upload the supporting documents. So once that is finished, the registration will be evaluated, right? And if it passes muster, then the NPC will just issue a certificate of registration. The other addition of the new circular is that aside from the issuance of the certificate of registration, the NPC will also issue a seal of registration. And it is a requirement that the seal be demonstrated in the entrance of the main office of the PIC or PIP, the Personal Information Controller or Personal Information Processor, or in any other prominent place, or actually the most prominent place. So the idea there is that it can easily be seen by the public. And also it must be displayed at the website of the PIC or PIP. Or if it's a global website, it must be displayed at the web page that is dedicated to the Philippines. So that's the first change. The second one, maybe it's not really a change, but it's important to note that it retains the requirement of mandatory registration. So what that means is that PIPs or PICs who are operating in the Philippines and who meet certain criteria have to register their DPS. And if you will ask, what is this criteria? Well, it's that they employ at least 250 employees, or they process the sensitive personal information of at least 1,000 persons, or they process data that is likely to pose a risk to the rights and freedoms of the data subject, or their processing involves automated decision-making or profiling. So if the PIC or PIP meets any of those criteria and they are operating in the Philippines, then registration is mandatory, right? And you might have noticed that I highlight the term operating in the Philippines. And the reason why I do that is that this term is now defined under the new circular. And what it means essentially is that it covers PIPs or PICs who, even if not established or founded in the Philippines, have equipment here or have a branch, an office, or an agency in the Philippines. So I think those are the particular things that I would like to highlight in respect of the DPS registration. The second item will be the new rules that the circular introduces regarding the appointment of data protection officers. Under the old regulations, a common data protection officer or a common DPO is available only to a group of related companies. So the way this has been interpreted is that it applies, for example, to a conglomerate. And also under the old regulations, the DPO, as a general rule, must be an organic employee of the company. And that is actually also the reason why it would not be possible for a group of unrelated companies to have a common DPO, because the situation where you are an employee of several companies would be very highly unusual. Now, that has been changed by the new circular. Under the new circular, a group of unrelated companies can now have a common DPO. And this common DPO, it need not be an organic employee. He can just be an individual under consultancy contracts with these various unrelated PICs or PIPs. So that is a relaxation of the rules, but it also seems to highlight that the occupation of a data protection officer is really a technical occupation by a professional engaged through consultancy agreement.
Wonderful, Franco. That's extremely interesting because it means that the regulation is pushing companies to look for someone that really has experience in the sector instead of having just someone coming from the company. So that's definitely a very good news for everyone that cares about privacy.
Yes, that's right.
Franco, anything else you wanted to add?
Sure. This is a new circular. But essentially, any companies who would need to register will now need to register under this new system. And this would include companies who have been previously registered because the previous registrations have a validity of only 1 year.
Okay, thanks a lot for this reminder to our audience. Of course, For any additional need, I invite everyone having business in the Philippines to contact Franco and the team of CIC Flow. I would also like to thank our audience for being with us today, and I invite you all to meet us with the next Privacy Espresso next week.
Yes, thanks, Alessandro. It was our pleasure.